Thank you, Mr. Chairman. Judge Koh, welcome. As I look at your record is concerning from the perspective of a judge who will faithfully apply the law. As I look at your record, I see the record of someone who's been an activist her entire adult life. When you were a law student at Harvard Law School, you participated in a 25-hour sit-in in the dean's office, pressing for racial quotas in hiring at law school. At the time, you described your views of judges, where you said the problem of the American legal system was the homogeneity of the bench, and your proposed solution was, quote, minority judges still need to maintain the disguise of objectivity or else face challenges to their decisions. You went on to say, yes, that minority judge is going to identify with their own experiences, but she can't admit this. We've got to get more clever and say, look, we're just as neutral as any 60-year-old white man. What's more pragmatic, to pretend we're objective or to deconstruct objectivity itself? Now, you've tried to back away from that statement since then, but what on earth did that mean?
Let me first say I have never advocated for quotas. Quotas are unconstitutional. As I said, I do disagree with that statement completely. That was 31 years ago. Since then, I have been a federal criminal prosecutor. I have been a judge on the state court hearing 500 cases a week. I've been a federal district judge for almost 12 years, hearing 719 cases a year, and I have 3,250
So my question was, what does that
opinions.
mean? Not how many decisions have you heard as a judge? What did that mean when you said
No, I'm just saying that there is a record to determine.
Judge, you're familiar with asking questions and answering questions. What did you mean when you said that?
It was 31 years ago. I don't recall specifically, but I'm sure I said, what I said is what I meant at the time. I think it's completely wrong. I disagree with it. That's not how I've lived my life, how I've served
So
the
I guess the
government.
challenge is what you
Yes.
said is that that at the time, when you were in law school, you weren't a child, you were a student at Harvard Law School. You said that judges need to maintain the disguise of objectivity and get more clever and pretend to be objective. And a difficulty for this committee is if you were following that instruction, you'd say the exact same thing right now, wouldn't you?
I am under oath, and I am telling you that I completely disagree with that statement. And you can look at the
All right,
271 trials I've had.
Then let's go to your judicial record, because as I look at your judicial record, I am concerned as well. Recently, you determined that a state regulation that banned Bible study, that banned collective prayer, that banned worship in an individual's home, while at the same time allowing activities like in-home commercial filming, was neutral and generally applicable. According to you, according to the decision, apparently people who attend Bible study are a greater threat under COVID than movie stars when it comes to health and responsibility. Now, that decision, of course, went up to the U.S. Supreme Court, and 6-3, the Supreme Court said, no, you're wrong. What did you get wrong?
The Supreme Court in Tandon has held that when you're looking at comparable activity, you look at the government interest that's asserted and not the reasons why people are gathering. That clarification has been very important. That is what I will fully, faithfully, and fairly apply going forward. They also
Why
said
did you
can't
think
assume.
that movie stars somehow are held to a different standard than people coming to a Bible study?
I was following the Ninth Circuit precedent. They looked at all the restrictions on the moving industry and said that the risk transmission risk was lower because of all the restrictions. They had mandatory multiple testings per week, and they had a lot of restrictions that said that they had scientific evidence that the risk was lower.
Your opinion applied rational scrutiny to this restriction on religious freedom. The Supreme Court reversed that and applied strict scrutiny. There's a world of difference between rational basis and strict scrutiny. Again, why did you get it so wrong? And how can the American people have comfort that if you're a Court of Appeals judge, you will faithfully protect their rights to religious liberty?
I applied strict scrutiny as well, and I was following Ninth Circuit precedent at the time, which said you look at the risks of transmission and you go through 7 factors to consider it. And at the time, the Sixth Circuit decision, which was not enjoined by the Supreme Court, said if you have a neutral, generally applicable rule that applies to both religious schools and public schools and other private schools, that survives strict scrutiny. And so the precedent that existed at the time is what I followed in issuing my decision.
But answer my second question?
I fully understand that Tandon is the law of the land. That is absolutely what I will follow, that you cannot assume the worst when people go to worship and assume the best when they go to work, and that you have to look at the government interest at stake, and that all of the rulings and holdings in Tandon, that's the law of the land. That's what I will apply going forward in any case that raises these issues.
Thank you, Senator Cruz, Senator Ossoff, Senator Blackburn, and Senator Padilla.
Judge Koh,